Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a Lawcast series talking about the recent change to allow confidential filings of registration statements by all companies. Title I of the Jobs Act, initially enacted on April 5, 2012, created a new category of issuer called an emerging growth company, or EGC. The primary benefits of an EGC include scaled-down disclosure requirements for both an IPO process and ongoing reporting requirements, confidential filings of registration statements, certain test-the-water rights in an IPO, and an ease on analyst communications and reports during the EGC's IPO process. Although EGC disclosures and rights are similar to smaller reporting companies, they are not exactly the same. As a reminder, the definition of an EGC when it was first enacted on April 5, 2012, was a company with total annual gross revenues of less than $1 billion during its most recently completed fiscal year that first sells equity in a registered offering after December 8, 2011. It could not have gone public before December 8, 2011. An EGC loses its EGC status on the earlier of the last day of the fiscal year in which it exceeds $1 billion in revenues, the last day of the fiscal year following the 5th year after its IPO. So, for example, if the issuer has a December 31 fiscal year end and goes public in an IPO on May 2nd, 2016, it will cease being an EGC on December 31, 2021. Third, the date on which it has issued more than $1 billion in non-convertible debt during the prior 3-year period, or lastly, the date it becomes a large accelerated filer, i.e. its non-affiliated public float is valued at $700 million or more. EGC status is not available to asset-backed security issuers, or ABS, reporting under the Regulation AB. It is also not available to investment companies registered under the Investment Company Act of 1940, except that it is available to business development companies, or BDCs. On March 31, 2017, the SEC made inflationary adjustments to the definition of an EGC by increasing the definition by 70 million. Accordingly, an EGC is now defined as a company with total gross revenues of less than $1.07 billion, and each of the factors that could cause it to lose an EGC status have likewise been changed upward to $1.07 billion. Regulation A+, as enacted on June 19, 2015, also allows for confidential submissions of an offering circular by companies completing their first Regulation A+ offering. Confidential submissions under Regulation A allow a company to get the process underway while soliciting interest of investors using test-the-water provisions without the negative publicity risk if it alters or withdraws the offering before qualification by the SEC. However, the confidential filing and all SEC comments and all amendments must be publicly made available and filed as exhibits to an offering statement at least 15 calendar days before qualification by the SEC. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of Lawcast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.